Tyrone Grayson, case number SP 146436761, SP 146409991, SP 1463900, counts 1, 2, and 3. State your name for the record.
Grayson
Bay. I'm sorry.
Thank you.
State your name for the record.
Grayson Bay.
All right. This is today is the date and time set for a jury trial. Ms. Schneider, can you put your appearance on the record, please?
Your Honor, Alexis Schneider for the people, P80322. For the record, the issuing officer, Officer Ambrose, was present, although I released him.
Mr. Grayson Bay, we didn't conclude some of the. First of all, I want to get the record straight from yesterday. I did mention, and you did cite. Where's Mr. Grayson Bay's file? Yes, but I brought it back downstairs. Yes. I wanted to clear up something I said on the record as far as the case that you cited out of Alabama. That I was incorrect as far as the facts of that case. Shuttlesworth was not the case where they were walking down the street and did not obtain the license to assemble. That was a case where he has another reverend organized a sit-in and at a restaurant. The unfortunate part about it is, and that's just how our society is, and it was, and still is for the most part, is that this case had to go all the way to the United States Supreme Court for him to get justice on this case. But again, you're citing cases, sir, that you're not even reading.
Right out of the gate, the defendant launches into familiar sovereign-style arguments, clearly expecting them to land. Instead, the judge calmly but firmly dismantles the logic, correcting legal misunderstandings line by line. What makes this moment hit is the contrast. The defendant speaks with certainty, while the court responds with precision. You can feel the power shift immediately as the judge establishes control and makes it clear this courtroom runs on law, not ideology.
Fine you. That's something a lawyer would be can be brought up to the grievance commission on and potentially lose their license. All the cases in there, all the cases that you have cited are saying exactly the opposite of what you purport. Have you looked at any of them?
Yes, Your Honor.
And you read them? When did you do that last night?
I've been studying more science. My religion is more science. As you can see, if it looks like a duck, it acts like a duck, it tells you it's a duck, it's pretty much a duck. So I'm more science. So I've been studying for over.
In this stretch, things heat up fast. The defendant doubles down, insisting the court lacks authority and leaning on pseudo-legal language. As a third-party observer, it's clear the judge has heard this script before. Without raising their voice, the judge methodically breaks apart each claim, exposing how recycled arguments collapse under real statutes. The tension grows as the defendant realizes confidence alone won't override procedure, and the courtroom atmosphere tightens with every rebuttal.
But you haven't been studying.
No disrespect to you, Your Honor. I just want to remain mute to the fact and acknowledge that my mother is here, the matriarch of my family, and so I just want to remain mute to this case in this matter. And the floor is yours. This is your courtroom. No disrespect. My mother is here.
No. Ma'am, can you stand up and state your name, please?
My name is Mary Grayson Hall.
Good morning, Ms. Grayson Hall. And it's nothing about you can see it. I just wanted you to acknowledge. I do acknowledge the fact, and I appreciate the fact that you have support here. The court always recognizes that. That's why I asked you to stand up. But you want to remain mute now. But you didn't remain mute when you filed these pleadings. This is how you speak to the court, exactly the way you did. Now, maybe the form is not exactly the way the court kind of or the rules have to fly, but I understand you're in pro per and you might not know all of those rules. But when you start filing these documentations, you're speaking to the court and you're representing that this is the current state of the law as this is the current state of the law, and this stuff applies to your case, and I should be reading this stuff and be able to interpret what you're saying about your case through these cases. And when I read these cases, it says exactly the ones that I've read, and I've seen these cases filed before, it says exactly the opposite of what you're trying to say. Because what I understand you're trying to say is that you're trying to say that you don't need a valid driver's license to drive on the roads. You don't need proper registration on your vehicle, and you don't need proper insurance. And you're even going as far as saying that the police officers, and correct me if I'm wrong, that the police officers do not even have the authority to pull you over. Is that correct?
Again, Your Honor, I remain mute to the situation.
Here, the defendant tries a different tactic, going quiet while still attempting to control the narrative through filings and side remarks. From the outside, it's obvious this is a strategic misstep. The judge explains, in plain terms, that written filings and actions still count as participation. This moment matters because it strips away the illusion of loopholes. Silence doesn't stop the process, and the court makes that crystal clear.
My mother is here. No due respect to the court. My matriarch is here. And I gave you pretty much documents to read. And I'm standing on those documents, and I'm gonna remain mute. Thank you.
All right, so I've already found you guilty of the count of refusing to exhibit a driver's license, SP 1464091. I'm going to fine you on that case $240. I've already found you responsible on SP 1463901, expired plate. I'm going to fine you $145 on that. And I've already found you responsible on SP 1463903, insurance no proof, and I say guilty on SP 1464091, and that's a 240 for the insurance no proof. I'm going to fine you $195 on that. All right. As far as the other counts, I had in the note. Well, you told me off the record that you're going to dismiss SP 146436761 and SP 146390002. Is that correct?
That's correct, Your Honor.
So 145, 195, and $240, sir. When can you pay?
I will probably need after the holidays, maybe 3 months. I might get something up for you.
Are you working?
I do carpentry.
Yeah, you do carpentry. Are you working?
Yes. Yeah, I have jobs lined up.
Okay, so why do we need so much time?
They lined up. They're not completed. They're just future jobs.
This part marks a turning point. The judge moves from debate to decision, laying out findings and consequences with steady authority. Watching as an observer, you can see ideology collide head-on with enforceable law. The defendant's earlier confidence fades as the rulings stack up. It's a reminder that courtroom outcomes aren't shaped by arguments alone, but by evidence, procedure, and jurisdiction, none of which bend to personal belief systems.
So presently, you're not working.
Today, I'm not in court.
you got this play on words.
Yeah, I mean, traveling and
Is this
driving, I mean, yeah, there be the system. Play on word, I mean, it's the truth though. I mean, I gotta speak the truth to you, right? You
You're not
respect the truth?
working now. If you.
Okay, I'm not
asking
working
you-
today, I'm not working.
No. You're not, I'm asking you, why is it taking you
We-
3 months to get up? I don't typically give out 3 months to pay fines, especially when somebody's working, and especially in a career that's a skilled trade, that's a very lucrative career. So I'm trying to give you the time you need, but I need to make a good basis for that.
3
Because
months.
you're not giving me a good basis for giving you 3 months, and you're telling me you're a carpenter and you're telling me you're working. Now, if you're telling me you're a carpenter and I'm not working currently, then that's something that I can go with. But you're telling me I'm just not working today.
Right.
I'm gonna go to work tomorrow.
Now the focus shifts to accountability. The judge questions the defendant about work, income, and ability to comply, and contradictions start surfacing. From a third-person view, this exchange exposes the gap between what the defendant claims and what the record shows. Each answer tightens the corner they're standing in. The frustration in the room grows, not from drama, but from facts steadily closing every exit.
Giving you 3
I'm
months
very
for that.
optimistic, that's why I say, well, as this present, not, but yeah, tomorrow, I'm very optimistic about work, so yeah, yeah.
So you're not working.
Today, I'm not working. Tomorrow, I have grass work tomorrow to do. There are schedules to do, and I do have a future as a job to have things to be done. But as you saying, as I'm working, I'm telling you the truth, not as now, no. If that clears, if that makes you feel comfortable, no, I'm not working.
I'm trying to ascertain.
No, I'm
what's
not
going
working.
on, sir.
I'm not working. At this present moment, I'm not working.
And when you say you're working, you have some aspirations of working,
Yes.
like everybody does. We're
Yes.
looking for, well, not everybody, because not everybody is trying to work.
Right, exactly.
So
Yes.
you're not working now,
Right,
correct?
thank you, Your Honor.
Let me ask you this, ma'am. Is this the kind of, I don't know, I want to make sure that you don't need any mental health services? Do you?
You questioning my mental capacity?
In the final moments, the judge wraps everything up with clarity and finality, setting deadlines and reinforcing jurisdiction one last time. There's no spectacle here, just decisive closure. The defendant's strategies have run out, and the process moves forward without hesitation. If you found this breakdown insightful, make sure to like the video, subscribe to the channel, and we'll see you in the next video.
Because you're giving me these play on words. You're giving me all of this
Speak the
stuff.
truth,
You-
Your Honor.
you- I don't
Speak the truth.
I don't feel you're speaking the truth to me.
I'm not working today at this present moment. I'm not working.
And you're not working. You don't have anything set for tomorrow,
No, I don't.
right?
Nope, I don't. I don't.
You don't.
I'm
Do you
not
have
even
anything
working.
set for next
Nah.
week?
No, I'm just anticipating things. You're right. I don't.
Do you understand what I'm saying?
Exactly.
I'm just gonna get you out of here. I'm gonna give you till March the 5th. You can either Zoom in or come in. I'm gonna give you till March the 5th to have the stuff paid off. All right.
Can I get a total?